Good afternoon, everyone, and welcome to today's webinar, Understanding the Student Conduct Board Hearing Process. It's such a pleasure to have all of you with us today. Thank you so much for your flexibility in regards to rescheduling this webinar due to the snow and the snow days that we had earlier this month. A few logistical notes just before we begin. All participants are muted except for myself and our presenters. If you have a question or you run into a technological issue during the course of the webinar, please use your chat function, which is on your webinar portal. Please send your questions or your technological issues to myself, the presenter, and I will do my best to handle them immediately. During the webinar, if you have any specific questions that you would like to share with our presenters during the question and answer time at the conclusion of the webinar, please also use your chat function and send those questions directly to myself, the presenter. And during the question and answer session, I will make sure that they are conveyed to our presenters. Just a reminder, we are recording this webinar, and I will share the recording as well as the slides with everyone who has registered. And I will be able to do that tomorrow on Friday, so stay tuned for that. Okay, great. Let's get started then. So the Understanding the Student Conduct Board Hearing webinar was organized in collaboration between the New York State Coalition Against Sexual Assault and the New York State Campus Consent Consortium. My name is Michelle Carroll, and I am the Director of Campus Projects here with the New York State Coalition Against Sexual Assault, and I have the pleasure of coordinating the New York State Campus Consent Consortium. If you have any questions about either the work that NYSCASA does or my work with campuses or the work of the consortium, please feel free to email me or give me a phone call. My information is on the slide. I would also like to take a moment to quickly introduce the New York State Campus Consent Consortium and its programs to those of us who may be new to the work that we do. So we have a listserv of over 500 Title IX coordinators, university administrators, students, rape crisis center advocates, state police, campus police, as well as other stakeholders throughout the state of New York. So we are we have a quite comprehensive list, and we enjoy sharing upcoming trainings, in-person or webinars, as well as other resources and opportunities with that group. So if you have something that you are planning and would like to share, please reach out to me, and I will make sure it gets to our entire consortium list. In the start of 2017, the consortium organized a series of ongoing working groups for specific members of our list. Our working groups include an evaluation tools working group, a restorative justice working group, a working group specifically for Title IX coordinators, a working group specifically for campus advocates, and a very specific and exclusive groups just for students throughout New York State. So that can be university students at the undergrad or graduate level, as well as law school, technical school, medical school, dental school, etc. At the conclusion of this webinar, I will share, as I stated earlier, the recording as well as the slides, and I will also share the sign-up sheets for these working groups if you or your colleagues or students that you work with would be interested in joining. So before I introduce our presenters, I'd like to take a quick moment to do two very short polls. So the first poll, I would like for you to choose which of the following job descriptions and roles most closely corresponds with yours. So please take a moment to choose which of the following job descriptions: Rape Crisis Center Advocate, Title IX Coordinator, University Hearing Board Member, University Title IX Investigator, or Law Enforcement most closely corresponds with your job title. I'll just give it a few more moments, and then we'll move on to the next short poll. Okay, thank you for your results. We'll move on to the next one. Okay, so I am asking you to consider where you fall on a spectrum of understanding on the University Conduct Board hearing process and best practices. So please choose one of the following. If you consider yourself an expert on best practices, very familiar, unfamiliar with best practices, familiar with the basics, or unfamiliar with the basics. And just like this previous poll, I will not share the results. This is just to help me inform, or to help inform me, excuse me, of any upcoming needs that I can help address. All right, give it another moment for everyone to choose which of the following they would describe themselves, their knowledge level in regards to conduct board hearings. Okay, great. All right, so I would like to now move on to introducing our illustrious panel of speakers who have just been absolutely incredible in working with me to reschedule this webinar, develop this program, and I'm just thrilled to introduce them to you now. So I'm excited to introduce Denine Carr, who is the Title IX Coordinator and College Compliance Officer at SUNY College at Brockport. I'm excited to introduce you to Dan Greer, the Assistant Director for Student Conduct at the College at Brockport, Dr. Sara Kelly, who serves as the Associate Dean of Students and Director of Residential Life at the SUNY College at Brockport, and Christi Waldron, who has been with Restore. And I'm sorry, Christi, will you just remind me of your title? I apologize. Oh, I have it right here. Christi Waldron, who is the College Advocate Coordinator at Restore. So I'm going to turn it over to our foursome to lead us through today's webinar.
Thanks, Michelle. This is Sara here. Hi, everybody. We're excited to share our institution's processes and practices today, and we want to talk about, our model that we feel works best for us. But we also wanted to make sure that, from the start, you're aware that there are many other models and approaches that are successful, and we're happy to share ours with you today. I specifically asked a few of our colleagues here to present because they are an integral part of our process. And also we wanted to highlight that we have a very much of a team approach here at Brockport, and that you'll see throughout our presentation that there's a number of people in various roles that really help everything work and help make our system work for our students. And also wanted to emphasize that our code of conduct really guides our work. So if you're interested in reading more about that specifically, you can go to our website at brockport.edu/student-conduct, and our full code of student conduct is available online. And it does provide a really nice procedural overview of our process as well as our policies. So just wanted to refer you to that if at any point you wanted to review that throughout our presentation. We can go to the next slide, please. Michelle Denine's going to get us started. Next slide. Oh, all right. Is that advancing for everybody? Okay. Good afternoon, everybody. This is Denine Carr speaking. So this first slide really speaks to the fundamental aspect of any Title IX process. Any investigation needs to be thorough, reliable, and impartial in terms of impartiality. For instance, somebody who's an investigator should not be an advisor for either of the parties, either of the students. If there is a perception of a conflict, that perception is going to cause the party to believe that the whole process was unfair. So it's really important that not only the perception, but the reality of the process is one that is fair and impartial. In terms of the process,
It's being prompt, effective, and equitable. OCR is pretty clear about the fact that when we investigate, that the whole process from the time a report is made needs to be one that's very time sensitive. Hopefully within the 60 days that they're looking at. It doesn't always work that way. If it doesn't, we need to document that. We're going to talk about the issue of equity in a few slides. I guess the next slide. In terms of remedies, we need to keep in mind that we need to stop any discrimination that's occurring. We need to prevent it from happening in the future. And we need to look at what we can do to remedy the victim. Ultimately, if we are completing the process in a manner that follows the law, we will be stopping discrimination. In terms of remedies, though, let me just say a few words that if the reporting individual, we refer to at the College of Brockport somebody who makes the report as a reporting individual rather than a complainant. But if that person is impacted in terms of needing to withdraw from school, in terms of needing a no contact order, sometimes we may need to remove a student from residential housing or change housing. We take that into consideration. Every situation is very fact dependent, but it may be very important for the college to take those actions to remedy the victim or the reporting individual. Next slide, please. So in terms of equity, equity is really a part of due process, an essential part of due process. Equity doesn't mean equal, but it does mean providing the same rights to both parties, whether that is, letting them know that they each have a right to have an advisor present at all meetings, asking both parties if they have witnesses, asking them for evidence. They both have the same right to attend the hearing, etc. But for instance, and we also want to offer resources to both parties. But for instance, if one of them needs to ask for an adjournment of a few days, we need to accommodate that. But that doesn't mean that we're going to ask the other party if they also need an accommodation, if they want to adjourn the matter, and if that makes sense. And it also doesn't mean that if one party says that they've got 3 witnesses, that the other one has a right to exactly 3 witnesses too. It needs to be equitable, and that means fair, not necessarily equal. Next slide, please. Well, hopefully everybody is familiar with the New York State Enough is Enough law that was passed in July 2015. It defines, and it applies to higher education. It does not apply to K through 12, just for your information. It provides a definition of affirmative consent that all colleges and universities throughout the state need to follow. It also requires that every institution of higher education have an amnesty policy to protect students who may have engaged in underage drinking or illegal use of drugs when the sexual assault or sexual misconduct occurred. If we don't have an amnesty policy, that can have a real chilling effect on students. And so it's really important for us to advertise this with students, because I have found, at least in our college, a lot of the students, even though we let them know during orientation that we have such a policy, many of the students are unaware of it. The law also requires that we have a Student's Bill of Rights that sets out a number of things, and we need to post these Bill of Rights around campus. The Bill of Rights indicates that the students have a right to make a report to law enforcement, that they have a right to be treated with integrity, they have a right to have an advisor present, they have a right to be free from retaliation, and a number of different things. And that's all laid out in the statute itself. It also guides how we respond to students, and it requires this kind of mini Miranda that we're supposed to give students, which is in effect letting them know that they have a right to make a report with student conduct, they have a right to make a report to law enforcement, they have a right to do both, to do neither, they have a right to be free from retaliation if they make a report, they have a right to resources that are available on campus. So there are a number of things that we are required to provide to students when we respond to reports. We also have an obligation to provide them information related to who is confidential and who is not. I always let students know that I am not confidential, but that does not mean that I'm going to be talking about their situation with people who do not have a need to know. That I will only talk to people who have a need to know about the circumstances. In terms of the campus climate assessments, hopefully everybody's on their way to getting those done. Those are also required by law. And we also, it's important for us to continue to provide education to new students as well as certain student leaders and others on campus. And that is something that we need to continue to do. Next slide, please. One of the things that we need to do is provide to students, help them to understand what the difference is between the criminal system and our student conduct process. And oftentimes it's our Restore advocate who provides that information to our reporting individual. But SUNY has come up with a document that in plain language provides the difference between the two. And I apologize for not having that link on the slide, but if you just do a search for and punch in SUNY, difference between criminal and conduct, the link will come up, and that form is available for any institution of higher education to use. It's online. You can get it in PDF, and we provide that to every student when we meet with them. So in terms of if there's a criminal proceeding that's ongoing at the same time as we receive a report, we may need to wait 10 days if that criminal investigation is going on. So what we do, we will check in with the law enforcement agency to determine, if we do need to wait. And what the statute says is that we can only wait longer, place our investigation on hold for longer than 10 days if the law enforcement agency specifically requests any further extension and can justify why we need to wait longer. That really hasn't come up too much for us on this campus. We also need to let the reporting individual know that we can provide them assistance with their making a criminal report and or getting an order of protection, and some of our students have taken advantage of that, and Restore has provided that assistance, as well as we have in the Rochester area Willow Domestic Violence Center, which provides advocates to students who obtain orders of protection in family court and criminal court. When we first meet with students too, we offer them, we let them know that there are a number of different interim measures available to them. Whether it's what we refer to as faculty notice, a letter that goes out to their faculty that says that something is going on, there's some type of personal situation that has arisen. The letter does not come from me. It comes from the assistant to either the vice president or the assistant vice president of enrollment management and student affairs here at the college. And we send those letters out to students who are ill, who may have suffered a death in the family, et cetera. So it's not unusual it's not a red flag for faculty to receive this letter, but it simply is making the faculty member aware that there might be, that this student is going through something, and that the student understands that they are still responsible for their work, but asks the faculty member to give them some leeway. So that's one form of interim measure. Another one might be housing, whether it's changing the location of, it could be the accused student. There might be a situation where the reporting individual asked to be moved. We also enter no contact orders on a pretty regular basis. They are not a sanction. They're not disciplinary in nature. But our practice is to enter a mutual no contact order. And I know that there are different philosophies about whether if they should be mutual or not. But my feeling is that if the reporting individual does not want the accused student, does not want to have any contact with the accused student, then likewise they should not be reaching out to the accused student in any manner either. And sometimes the reporting individual doesn't request a no contact order, but we will issue it because it's appropriate in the circumstances, especially if it might be a situation of stalking, where there's been violence threatened and that kind of thing. And I'll just say, too, when we have a first meeting with a reporting individual, we give them a number of different forms. We go through what we refer to as the reporting individual's acknowledgement form, which has a lot of the information required by law. In there, we go through the resources with them, what their rights are, and we do the same thing with the accused. We provide both the accused and the reporting individual with a summary of a description of our investigation process. So we talk to them about it, but we also provide them with the paperwork because it's a lot of information to take in. And if they have the documents to refer to later on, then they can process it a little bit more. We give them the plain language explanation of distinctions between criminal law and the student conduct process, the one that's right off of the SUNY website. We give them the Student's Bill of Rights. We give the reporting individuals, and sometimes the accused students too, the list of resources, which includes our counseling center, Restore, University Police, Willow Domestic Violence Center. We have a brochure that sets forth various definitions of the violations in our Code of Student Conduct, and we give them a copy of the Code of Student Conduct. And we give reporting individuals a copy of the brochure from Restore. So we go through that. It's very standard. It's important that we're consistent when we give the documents out. And I also would like to provide something to accused students that provides more resources for them, because I think a lot of times the resources that we provide in our list of resources to reporting individuals aren't really applicable to the accused student. So I think that's one thing that we could work on a little bit more. Next slide.
Great. Thanks, Denine. So we're going to talk a little bit more about our process more specifically. I did emphasize here that, your code or whatever code the institution has should be guiding their work. But from the initial report, we typically get most of our reports from residential life, university police, student conduct, or student affairs professionals. But we do receive some reports from the other law enforcement agencies. And most of the time, our reports are not during business hours. So I think that's important to note. We have all of our on-call staff trained in residential life, for example, so they can go through the acknowledgement form that Denine referenced and provide options, resources, and support immediately rather than waiting, as well as our university police. They are well trained as well to know what our processes are like on our campus, what options the students have, and what resources they have right in the immediate report of the incident. And then we also have a Title IX case management team, which meets weekly to discuss cases and determine if an investigation will occur. We also talk through interim measures that Denine mentioned a little bit and what immediate and longer-term action plans would be required. So when we receive a report, we do work through the immediate initial report and how do we provide support, as well as then bring it to this team to talk through next steps as well. And the team has representatives from University Police, residential life, student conduct, Title IX, and health and counseling. So we really try to look at all the cases comprehensively to make sure that our process is not interfering with the criminal process, for example, that we provide adequate support to our students involved, and try and look again at the big picture so that we can collaborate to support our students on both sides of the case. An investigation, so the report would be received, an investigation, at least a preliminary investigation would occur to look into what's going on, and we have a co-investigation model. So two faculty or staff members are assigned to investigate each case, and this is not a separate job. This is in addition to their job. So we do quite a bit of training, and they're all certified and trained investigators for Title IX that are co-investigating. And they complete a very thorough investigation report. They meet with, obviously, all the students involved, their witnesses, collect evidence and information that might be relevant to the case, and complete a really nice and lengthy, typically very lengthy, investigation report that has all of the appendices, including text messages, for example, that might be in there, any type of documentation the students provided. And that is then given to the Title IX coordinator for review, and the Title IX coordinator serves in a gatekeeping function of sorts to determine if a hearing would be granted based on the information gathered in the investigation. So the Title IX coordinator would determine if a hearing would be granted or not. If a hearing is not granted, the reporting individual or any student involved, any student, including the accused student or the reporting individual, would have the ability to appeal. So if it's not granted, for example, the reporting individual could appeal that to have it be reconsidered. But if a hearing is granted and moves forward, there is a notification of charges with the investigation report. So the Title IX coordinator would issue the notification of charges with the investigation report to both parties involved as well as their advisors. So the students involved receive the complete investigation report and all of the materials gathered through the investigation. So it's a very transparent process. Everyone receives the same information, and it's, again, we include the advisors because they're supporting the students involved. And there's also, that would prompt the student conduct officer to be assigned to a case and start the hearing process, which would include a notification of hearing and talking about, all right, there's going to be a hearing, we need to schedule it, working through the place and location. And obviously throughout all of these documents, the charges would be fully explained and articulated so the students are aware what charges are being considered by the board. Also, moving forward with that, there would be a hearing. We could have administrative hearings or we have conduct board hearings. We are focusing more our presentation today on conduct board hearings because that was what we were asked to focus on. And we are required to, for all of our non-consensual sexual intercourse charges, we do full board hearings, where other charges, maybe non-consensual sexual contact or sexual harassment, could be an administrative hearing. And if it is a choice, if it doesn't involve the non-consensual sexual intercourse, the accused student has the ability to choose between administrative or conduct board hearing. So there will be a hearing, that would occur if the investigation, the investigation would warrant that or determine if that's appropriate. So then the hearing board or administrative hearing officer would determine the outcome, responsible or not responsible for any or all of the charges involved. Typically, our hearing boards have 3 board members on them, so that's something that we have well-trained faculty and staff that serve on those boards, and they would determine if the student's responsible or not, and then and issue our outcome letter, which would determine would articulate what charges the students are responsible for, and then the memorandum of opinion articulates why, so the rationale behind the decision that the board has made. And the students and their advisors receive those letters as well. And then after that, there is the appeal process. We have an appeal panel that would receive appeals on the basis of 3 things: severity of sanction, due process, and new information. So if the students involved chose to appeal, that's what they would focus their appeal on and submit that to an appeal panel for review. So I mentioned at the very beginning that we have very much a team approach to implementing our process and ensuring that it's a fair process. And there's a few different people I wanted to mention, different positions I wanted to mention. Like I mentioned before, the initial reports typically have come through University Police, Residential Life, Brockport Village Police, but could be anyone, honestly, a referral from Health and Counseling. Maybe they direct a student to our office to file a report. Okay. Faculty, yep, we receive reports from faculty as well. And we wanted to emphasize just the training of the people that typically receive the initial report. Denine had talked about the distinction between confidential and non-confidential reporting options. That's something that everyone is very well trained on, as well as other resources and materials they should be giving out so that the student has all of the information that they need to make the decision that they're most comfortable with. Obviously, there's a reporting individual, an accused student, or could be multiple of each involved, and Denine's done a nice job talking about how we specifically support them and different forms and resources we provide to them as well. Our Title IX coordinator, we have a Title IX coordinator and deputy Title IX coordinator who are both involved. In many ways, they serve as kind of a coordinating body, ensuring that the process is moving forward fairly, and are a good consulting person as well. They also ensure that our training is up to date and that the people involved in the process are well trained and able to serve in those roles. Our wonderful advisors, including our friends at Restore, we have a nice group of, a healthy sized group of faculty and staff who are trained to serve as advisors on our campus. And as you know, students can pick an advisor of their choice, but some students don't necessarily have someone they'd like to pick, so we always encourage and offer faculty and staff who are trained advisors to serve as their advisor if they like. Or Restore is really an integrated part of our process where we offer Restore and often coordinate a meeting with the student and Restore from the very start, so they have support in that way in what might be a very traumatic time. With their role, though, in the hearing, so any advisor would sit in any of the investigation meetings and be present to support the student and, answer questions or ask questions and so on. In the hearing itself, they would serve as a potted plant. So they don't actually get to participate, but they're there to support the student and assist in the hearing process that way, but not actually be a full participant in the hearing. I talked a little about the case management team. Again, we meet weekly and talk about the cases and make sure that we're comprehensively approaching them in supportive ways. Also, our investigators, we have a decent number of investigators. What are we at now, maybe 10? 10, roughly 10 investigators who were all very well trained. We used TICSA a lot. We've used SUNY training, the National Center for Public Safety, and we've invested quite a bit of time and money in our investigators to make sure that they're trained to do thorough investigations and that are also trauma-informed. And then we have a team of hearing officers and hearing board members. Again, a lot of training has been devoted, a lot of resources have been devoted to their training as well, that serve in this capacity. We're going to talk more about that in a little bit, as well as the appeal panel who also receive a lot of training. And I'm emphasizing training because it's a lot. It's really important. We think it's something that we've made an investment, and it's definitely paid off, and we've seen that help our students in the process and all of us be able to fulfill our roles. One thing I wanted to just emphasize that Denine touched on earlier on was the different roles that we all can play in and how we do not overlap. So, for example, I could be an investigator for a case because I'm trained to be one and I have been an investigator, or I could be a conduct board chair, or I could be on the appeal panel, but I would never be any more than one of those for any case. So, for example, if I'm the investigator, I wouldn't be the hearing board officer and I wouldn't be on the appeal. Or if I was the hearing board chair, I wouldn't have been the investigator and I wouldn't be on the appeal panel. So we want to make sure that we have pretty clear distinctions and we don't have any conflict of interest or have multiple hats that we wear whenever possible.
Thanks. All right. This is Christi Waldron from Restore, and I'm going to talk a little bit about our role here at Brockport. So like any other rape crisis program around the state, we provide support and advocacy through any systems, and particularly here at Brockport, our process for them contacting us is similar to an automatic call out that we might have in the community with our hospitals or law enforcement, where as soon as someone presents, they give us a call. So here at Brockport, they try their best, I think, usually to have us at the first or second meeting. It might depend on how the student reports and when and things like that, but usually either Denine or student conduct is reaching out to us to support the reporting individual from the very get-go. At that first meeting, our role is really to be just supportive and to let them know of all of their options. And of course, one of the options that we provide to them is that we could be an advisor for them going through the student conduct process. This system has, I think, worked out pretty well so far. Most students that we're at that first meeting for usually do keep us on throughout the whole process. Not all the time, but usually they do stick with us unless they had somebody else in mind. There's been other times where students had someone else in mind, but that advisor couldn't be at a meeting, and so we'll pop in and then we just refer them over to their advisor. There's been times where I start working with a student and then maybe the accused student gets a lawyer, and maybe the reporting individual feels like they want a lawyer now too, and that's totally fine, and we let them know throughout the whole process that they can have an advisor of their choosing, and that we don't feel bad if they decide to go with someone else. We know it's all about choices. So our role, of course, is as advisors through their system is to help explain the process, which of course the college is obligated and required to do. But oftentimes I find that when we leave those meetings with Title IX or conduct, a lot of times I'll have to debrief and go through everything again, even though they just heard it, which is fine. That's, that's part of the trauma and just kind of hearing so much information at once. And so we can debrief after all of those meetings. We're providing counseling if they want throughout the whole process. And then we can also help prepare them for the hearing itself. So we can help them prepare their statements. We won't write them for them, but we can at least give them an idea of what an opening statement might look like or what the closing statement might look like. In the closing statement, we usually try to set up more like a victim impact statement that you would have through the criminal process. But I know that the boards generally like that closing statement to be kind of set up as an impact statement and how this has affected them. And then we can also help them prepare questions for the accused student and for any witnesses that might be at the hearing. We do our best to make sure they're appropriate and relevant and worded correctly, and try to have those written, before the hearing. And of course, sometimes during the hearing we're coming up with questions on the spot as well. And then, of course, during the hearing, we're providing support. Even though we can't talk, we can whisper, we can write notes back and forth to each other, and I can ask for breaks, usually with a timeout hand signal, or, if there's something that, I think might not be going well, or if I can tell that my client is getting frustrated or irritated with something, I can ask for a break and we can have a discussion out in our waiting room or out in the hallway, and be in constant contact with the board chair on those breaks to kind of let them know how the client's feeling. And then after the hearing, we go with them to the outcome meeting and provide support through that as well, whether the accused student is found responsible or not responsible, and kind of do some support and debriefing around the outcome. And then, of course, we stay in contact with them for as long as needed after the whole process. Throughout the process, too, we're doing a lot of checking in about how they might feel if the accused student is found not responsible. I think that that's very important to start looking at what that might be like for them, and go over some coping skills with them in case that is the outcome as well. So that is our...
Yeah, I'll just add that Christi's done a great job, and so has her team, in terms of really taking time to study and understand our process. Our Code of Student Conduct is lengthy. I mean, it's very lengthy. And it's lengthy in a great way that's detailed so students understand what to expect. But one thing I've always appreciated about the Restore advocates is that they take time and really review it, and they know, great questions to ask, and they're going into it very informed, which is, somewhat optional. And I think that's been really helpful in our partnership for them to also be equally informed on our process, just like we're informed on their resources and support services they offer.
Yeah, we definitely do a lot of cross-training, and I think that has been so helpful. So if you're a rape crisis program that's on this webinar, definitely I would start with your colleges there outside of any systems and hearings that might be going on, and build the relationship before any cases that you might be getting pulled into, and offer training and let them train you. And that has been I think really beneficial here for us. And
yeah, and just an example of that was Christi and her team came in and did trauma-informed training for our conduct board, as well as the Brockport Village Police and University Police, and we all together did one giant training, and it was a nice way to show partnership, but then also, receive some great information.
Thanks, Christi. In terms of the investigation, Sara has covered a lot of this. As she said, we have a co-investigation model. Our investigators are neutral fact finders. They are neutral. They're not the fact finders. it is either it's the board or the administrative hearing officer who is the finder of fact. So the investigators are simply gathering information and then preparing that investigation report. In terms of the advisors, I think we've covered that too. That's something that we really do strive to do, though, is reach out to somebody from Restore at the get-go for the reporting individual at that first meeting. It doesn't always happen, but that is certainly what we strive for, is getting Restore involved at the very beginning. And Sarah talked about some of the training that we've been involved in, that we attend, the ATICSA, the Association for Title IX administrators. There was just a training in Buffalo, for instance, for investigators. That's very they're pretty well known nationally. SUNY has put on one-day trainings for investigators for about the past year, which have been very successful and have been free to SUNY schools. NCCPS training we just sponsored last October, and that was very helpful, I think, in terms of, again, being trauma-informed. And moving into the trauma-informed questioning, that is something that we are really focusing on more, and there are a couple of slides later on about that. Again, being prompt, thorough, and fair, those are really key elements of what we need to do in any investigation. And sometimes we may need to delay, as I said, because of scheduling reasons, whether it's the parties or advisors, whether it's the investigators who are out of town or not available, whatever. But sometimes we also need to put a pause on an investigation if we realize that we need to follow up on some other information. Maybe a witness name came up that was new to us. In order for the investigation to be comprehensive, sometimes it needs to take a little bit longer to make sure that we are doing the job that needs to be done. The gatekeeper function Sarah touched on, and I think that's the following slide too. So at the end of the day, when the investigation is completed, again, we provide the report to both the parties and their advisors. And the report indicates whether or not we are recommending a hearing. And at that point, if there is a hearing recommended, then at that point, charges are brought against the accused student. That is that first step in terms of bringing charges. Up to that point, it's been an investigation. So the gatekeeping function. When a report comes in, there's some information that would lead us to believe that it might be some type of sexual misconduct, relationship violence, or stalking. So we will follow up and try to gather more information. It might be a preliminary investigation, because we need more information to determine if we need to go forward with a full investigation. In most situations, we do proceed with full investigation. And our standard for whether or not we refer the matter to a hearing is whether, if the allegations are true, they may constitute a violation of the Code of Student Conduct. We know that under enough is enough, there are definitions for many of these, many of the terms for sexual misconduct, and we need to make sure that we are following that. But every Code of Student Conduct is going to be different in terms of what your standards are and at what point you decide you're going to refer something to a hearing. So ours is a very low threshold in terms of whether or not we refer a matter to a hearing. It's a different standard, obviously, when we get to a hearing, because that is preponderance of the evidence as the law requires. As Sarah said, Title IX coordinator, that's me, and we have a deputy coordinator. So if one of us, if I'm investigating a case and I don't oversee it and provide guidance and answer questions about it, our deputy Title IX coordinator does that. Just looking to see what else we have here. Yeah, I talked about granting or denying a hearing. The investigators will consult with the Title IX coordinator, deputy, to determine whether or not we think that there's enough there. Sometimes it really is a difficult assessment, in that case, sometimes we involve our general counsel to get his input, and other times we decide, and I have had this discussion too with our general counsel that if we're talking about it and going back and forth that much, we should just go forward with the hearing, because if it's that close, we need to just go ahead and let somebody make a decision based on all the evidence about whether the accused is responsible or not for the conduct. So.
Do you have anything about when we proceed against their wishes? Is that later slide?
Let's see.
That might be a good
Yeah.
time to talk about that.
Dan is asking a question about the issue of when we may proceed when the reporting individual does not want us to. And the law says under enough is enough that, you know, we need to honor the wishes of the reporting individual, and we want to do that because it's not a good place to be when you're sitting across the table from a reporting individual who is telling you they don't want to do anything, you know. They don't want to ruin this other person's life, or they're downplaying maybe what happened. You know, it's hard to know exactly. Because at our first meeting with the reporting individual, we are providing them information about our process and what their rights are. We are not gathering more information from them at that point. That is not the purpose of that first meeting. The second meeting, when we take their statement, is when we do that. So, but we have some information generally at that point, which is why, you know, we're meeting with them in that first meeting. But what the law says is that we may proceed even if the reporting individual does not want us to, if the accused has a history of violent behavior, and I'm reading this directly from the statute, or is a repeat offender. If the incident represents escalation in unlawful conduct on behalf of the accused from previously noted behavior, so if there is some pattern of behavior, and this is an escalation, or if we have reason to know that, for instance, in a dating violence situation, that there's been some violence and it's getting worse. If there's an increased risk that the accused will commit additional acts of violence, whether the accused used a weapon or force, whether the reporting individual is a minor, and whether the institution possesses other means to obtain evidence, such as security footage, and whether available information reveals a pattern of perpetration at a given location or by a particular group. So those are the exceptions that we look at, and we have had to move forward on some occasions because of these exceptions and because of our concern of continued violence or an escalation of violence or sometimes a pattern. Those are hard decisions to make. I have tried in more recent past to explain to reporting individuals at the outset that we will try to respect their wishes, but that we cannot always do that. And sometimes I let them know that based on the information we have at that first meeting, even if they don't want us to, we may still need to proceed. So that's part of, I think, kind of preparing them for what might happen in the future. And I think that's very important. And I really appreciate the work that Christi and Restore does along those lines, because I think a lot of preparation for what might happen down the road and how the reporting individual might feel as a result of one finding versus another is just really important in terms of their emotional well-being. So I think we can move on to the next one.
Hi everyone, this is Dan, hopping in for a slide now. So as we've talked about in our process here at Brockport, we have a distinction created between what we call administrative hearing versus a board hearing. And this is for all of our student conduct cases, including our Title IX related cases. The only time, and we've talked about this already, the only time that a student does not have that option is when a student is accused of a charge of non-consensual sexual intercourse. And in that type of instance, it would automatically go to a board hearing where we'd have a panel of 3 or 5 trained faculty and staff members. Typically in our board hearings, we also train students for our general conduct hearings, but when it comes to Title IX cases, we focus on our faculty and staff members because of the nature and the sensitivity of these cases. So some of the primary differences are that in an administrative hearing, we have 1 student conduct officer versus that panel of 3 or 5. So if an investigation is proceeded and say I have been assigned as the conduct officer, in an administrative, I would be that 1 student conduct officer meeting with those students and preparing them. But in a board hearing, my role would be to be the board chair. And in that role, I don't have a vote when it comes to deciding, but my role then becomes preparing the board, setting up the logistics for everything with that hearing, and then also making sure that they are staying relevant to the case when they're deliberating and making appropriate decisions. Another major difference that comes into consideration for students is the difference between the audio recording. In an administrative case, it looks a little bit more informal, and really the only record that's created from that are my notes, that I take handwritten notes, and then the outcome letter, and then the memorandum of understanding, which provides that rationale. In a board hearing, you have that, but you also now have an audio recording of the whole case. And in the case of an instance where a student appeals, we also create then a typed transcript. Where that's really important that students would sometimes take that into consideration is if there's a court process and then now there's additional record that could be subpoenaed by a court. So that's a really important thing for students to consider, and students that are working with attorneys may advise them against the board hearing if they have that option. So I indicated that, again, that there'd be no transcript of an administrative case. In terms of the setup, and we'll talk about that in a later slide, but in terms of the setup, they look very similar, except for the difference of the one person. We will still, go out of our way to prepare the students as best that they can, for those hearings and make sure that they're knowledgeable about what they're walking into and preparing for. And occasionally, depending on the complexity of the case, because sometimes with these cases, our investigative reports, by the time you add in all the appendices and all of the notes, they can be reaching 80, 90 pages. And then I'm also working with an accused student and a reporting individual and also courting witnesses. So I will sometimes invite another person who's been trained in conduct with us to help me take notes for that administrative hearing, so that I can focus more on logistics and the interaction with those students. Another thing that students sometimes take into consideration is the time to resolve in those hearings. By the time we've gone through an investigation, there's already been a lot of time committed, and simply because of the number of people involved, we are able to schedule an administrative hearing quicker than we are able to get a board hearing scheduled. So students will also sometimes take that into consideration if they have that option, on trying to get that resolved in a quicker manner. I'm seeing the question already about the board hearing being optional. Yes, it's optional unless it's non-consensual sexual intercourse. And I should say that the reason that we do that is because in SUNY, if a student is found responsible for non-consensual sexual intercourse, we only have two options then for sanctioning, and that's suspension or permanent dismissal. And with those stakes being so high, we have decided that a board hearing is the best option for that consideration.
Great. So going into our hearing process, so we've talked about how the investigation report is shared and the charges and notification of hearing and the different choices so far. A couple of things we haven't talked about is before the hearing, we have pre-hearing meetings with the students involved and their advisors, and those are separate meetings. We really never have both parties in the same meeting. For example, so if the reporting individual and their advisor, they would have their own pre-hearing meeting with the conduct board chair, and then a separate meeting would be scheduled with the accused student and their advisor. And the goal of that meeting is really to talk about, the process and make sure the students feel comfortable going into it. It can be an intimidating process. Most college students don't expect to be involved in a process like this. So we talk about what to expect, how to prepare, what are the specific charges involved, and hoping that they've read the investigation report and encourage them to do so. Talk about their rights, and also say, is there anything that you've not given the investigators that the board would need to consider, which is rare because the investigation is pretty thorough, and it's not common that we receive any information outside of the investigation, but there's times when we do, and we offer that opportunity. We also discuss participation options. So the students involved have quite a few options to participate in the hearing. They cannot participate at all. They can participate fully, where they are present in the room, both parties are there. They could have a partition available that separates both parties. They could participate via phone. They could be there and be present but not participate. So there's a lot of different options, and also ways that we try and protect the students' privacy and respect their privacy should they want to have a partition or call in instead of be physically present, Skype in, whatever that looks like. We also have pre-hearing meetings with the board, again, separate from the meetings with the students. And the board chair would meet with the board members and review the materials, again, kind of prepare for the hearing, but then also do a refresher training. The board members, and we'll get into this in just a few slides, go through a lot of training, and we like to do a little refresher training on that, and specifically for Title IX cases because they're so complex, and want to make sure that the board has that great training right in front of them before they go into a hearing. The hearing itself, Dan's going to show a visual of the setup in just a couple slides, or just a slide or so. But the general order of events, the reporting individual would typically start with an opening statement, which they can choose to do or not do. We have some students that like to write their own and a new one, others that may read their summary from their investigation report statement, or some that choose just to say, I've said everything I need to say to the investigators, and that's that. And then just be asked questions if that's what they want to do as well. Then the board chair or the board members and board chair would be able to ask questions of the reporting individual directly, and that would go on, for however long they needed to. And then the accused student would have a turn to propose questions. And I say that because neither student can ever directly question each other. They need to ask all of their questions on question request forms that are submitted to the board chair for review. And the board chair would review whether or not the questions are appropriate, redundant, victim blaming, and determine what can be asked, what can be modified, and what would be blocked. So the board chair is a pretty big job and a challenging job at times. So there's times when we take breaks. We might receive a number of questions at once and might want to take a break and review them before proceeding. So basically then the same thing would happen with the accused student. The accused student would have the opportunity to do an opening statement. The board members and board chair could ask questions. Then the reporting individual could propose questions to the board chair, and so on. So after that, we would start inviting witnesses in, should there be witnesses. And after the witnesses, they could be questioned by the board members and board chair. And again, the accused student and reporting individual could propose questions in writing to the board chair to be considered for the witnesses. After all the witnesses, there could be an opportunity for the board to ask any remaining questions of the parties involved. But typically we'll go into a break for then the students prepare their closing statements. Then the closing statements would occur. Typically the reporting individual will go first, then the accused student, and then that would end the board. And the board chair would separately dismiss the students from the hearing so that there wouldn't be any opportunity for them to cross paths, and then the board would meet to deliberate. A couple of things to note that are important for our hearing process that we think help make the process as smooth as possible is we do try to have separate spaces for the witnesses to wait in. So if we have 4 or 5 witnesses, we might assign them different lounges or different areas to wait in, and we'll get them so that they're not kind of chatting about the case while they're waiting. And if we have a number of them, we might actually get a volunteer to help us coordinate that and be in the hallway with them because they're not present in the hearing. We don't have outside guests in the hearing. It's only the people that are immediately involved, their advisors, and then the board. We invite witnesses to come in and out specifically during their time to speak, but we don't have people that just watch the hearing. Also, we have separate waiting rooms assigned for each student, so the reporting individual and the accused student have separate waiting rooms where they can meet privately with their advisors during breaks to prepare their closing statement, even before the hearing. And that's been very helpful just to make sure that people have a place to prepare and feel comfortable, and also meet privately with the board chair to ask questions if they have questions throughout. It sounds really bizarre, but we do assign bathrooms, and we think this is important because it helps, again, create comfort for our students involved so that, for example, maybe we assign the accused student the bathrooms on the first floor. If it's a 2-story building, we have one building we typically use that has 2 floors, and then we might assign the reporting individual the opposite floor, for example, so that, even if they're different genders, maybe their advisor isn't, and there's not any weird crossing of paths in the restroom, for example. We've talked a lot about the questioning process, or a little bit about that so far, and that's very important for us. But that's the general overview of the hearing process, and we're going to go into a little bit of the setting. We set it up now.
So this is our an overhead shot of our default setup of a room for a hearing, and this is for a board hearing. As you can see, we would have the reporting individual on one side with their advisor and the accused student on the other side. And by default, we would have a partition in the middle there. And typically some of the rooms that we use also, I didn't put it in this visual, but there's two doors so we can coordinate a door on either side of that partition for them to come and go. Well, not come and go freely, but to be able to enter and not cross paths. In the middle, we'd set up a recorder. So we have a 360 microphone that sits in the middle that extends to record to a tape recorder that would sit on the table with myself as the board chair. And then the witnesses sit over there on the side. What's important for where the witnesses are sitting is that they have line of sight with the reporting individuals, the accused students, and with the board. And we found that that's really important because there's been hearings before where we've gotten a lot from some of the visual cues that the witnesses are giving us. And it's really important that whether that's a witness that is supporting statements from the reporting individual or for the accused student, but that those students are also picking up on some of the tone and the visual cues of those witnesses. We coordinate moving in and out of the room, but we also talked about some of the options that these students have. And occasionally with these defaults, we may have students that are participating not in the room, but are participating through, say, Skype or phone. If they can't be in the room, then Skype would be the next best option. For instance, we had one case where the reporting individual was actually a student at another school, and so I worked with our IT to have a setup with a TV cart and a webcam that sat on top of the TV, and that we had to play with the setup a little bit so that as the board chair, we were able to see the TV, but the accused students then sat a little bit behind the TV, so they never saw what was on screen, but then could hear her as she was participating, and she could see us and we could see her. So that was something that we really needed to think through creatively for that hearing, and it's really important that if you haven't thought through it, to try to maybe be proactive about, well, what if you have these types of situations where you would need to think of, and what would you need to plan ahead for, and the more you can just know where your resources are for your logistics, the better set up you would be, so that when a student tells you a weekend ahead, I want to participate by Skype, you're not in the process then of trying to purchase a webcam or set up a Skype account, with short notice. So just some things to consider in terms of our options with participating.
Yeah, so we talked a little bit about training and some big things that we have utilized in terms of a TICSA, SUNY training, National Center for Public Safety. But here's some topics that our hearing board is trained on. And the big question is always, are they required to go to all of them? And the answer is no. We do require them to go to the General Conduct Board and Sexual Misconduct Board training, which provides overview. They're pretty lengthy and get into a lot of our main points of training. But we always tell the board members that we won't select you to be on a board unless you go to more than that. So it's required to attend more in many ways as well. And we always try to provide this ongoing training, and we roughly have about 2 a month. And we're looking at modifying that a little bit, maybe doing more of like a retreat style. But for now, this is kind of what we do, and we're looking for next year to maybe do a longer time, maybe a half day or full day training before the semester starts, and then moving forward with some refreshers throughout the semester. But there's a variety of topics, as you can see, that we presented on the past and had trainings on for a hearing board. One thing that's important to note is that we don't necessarily do all of the training ourselves. We might bring in experts or outside presenters to present to the board. And, Christi's presented a number of times from Restore. We've had people from Willow. We've had our AOD counselor present. We've had local judges, the chief of police. there's a lot of different people that we've relied on and that have come in and done training for our team. Also, we use some webinars, like this wonderful webinar today. But we use some webinars from the Association of Student Conduct Administrators, ATICSA, FEDI training. And those are nice because we have typically purchased them, and we've been able to replay them and over time because we've bought that training, and it's nice to break things up too. It's not always us presenting every single time. So there's just a general list there, and we're always continuing to review that and modify that to make sure we're looking at relevant topics.
So of course we do some ongoing training with our board, which Sara already spoke to. But when it comes to being selected on a board, and we have our 3 or 5 people selected, then as the board chair, we pull them together and help prepare them with the case. One of the things the first thing that we'll do in that meeting leading up to the actual hearing is we will do a refresher training. That's an overview again of what are the charges in play and what are some of the definitions. But in those definitions, then what are the criteria that we would have to meet to find a student responsible? We'll also focus in some slides and some information into the relevant issues. So, for instance, if we have a case about that seems to be that the primary issue is incapacity, we'll look at some slides about that incapacitation and what does that mean, and what are some of the information again that we need to determine whether or not a student was incapacitated and unable to give consent. But then we'll also have slides in there that focus on questioning, especially focusing on what we need to know. And that carries us into where we spend a lot of time also with that session is reviewing the investigative report and focusing on what is the relevant information that we need to establish in order to determine whether or not there's a violation of the code of conduct. So things with where there's a non-consensual sexual intercourse case, we need to focus on, is this a case where we're talking about force, or was it a incapacitation case, or is the primary question whether or not there was affirmative consent? If we're looking at a sexual harassment case, now we're looking at, okay, was the conduct welcome or unwelcome? Was it based on gender, sex, or gender stereotypes? And was the conduct so severe or pervasive to have impacted that student's ability to access the academic environment and the services provided by the college or university? So then once we determine what are some of the core issues there, we're also looking at what are some of the relevant sections of the student's statements and then narratives. So really, if we're looking at a case of non-consensual sexual intercourse, a student may give us a statement that plays out through the entire night, and if a student has been drinking, that's really important through the evening. But we also really want to focus on what are some of the facts that we need to determine whether or not that incident was consensual. So we want to focus on what are some of the facts that establish that. And one of the things that I think is great that we have in our investigative report is we'll have all the statements, but our investigators will also lay out where are the facts that are already established and already agreed upon by the parties, and then where are there facts that are still in disagreement. And that helps us focus as a board in establishing, okay, we don't need to spend a lot of time because this has already been established as this happened, but here's areas where there's disagreement and we need to get some clarity. So I have found doing this here has really, I think, been successful with the board with helping them figure out where to focus and where to be asking questions that are important and necessary, and not getting off on track of questions just because they're curious about something, which is really important. So also some other general tips, and this one sounds, might sound common sense, but hearing the case before we decide it. And I think even for our experienced conduct members, you read the report, and you might have an inclination of what, a responsibility or not of responsibility before you go into the case. So I really stress with our board members too to keep an open mind before you go into the case, and make sure that you're not leaning one way too far, because that might impact if you've already got your mind made up, that might impact how critical you're asking your questions of one party or the other, and not thinking because you feel like you've already had the information that's established. And also not leaving your mind open for some of those curveballs that might come out in the case if one party says something that's now completely different than was recorded by the investigators, or we have had witnesses come in and completely change their statements. And I've even had cases where witnesses have come in and said, what I told to the investigators, was pressured upon me because of what the reporting individual wanted me to say. Here's the truth. So we've had that happen, and it's really important for our board members to take that investigative report, but then walk into the case with an open mind and let the facts lead where they're going. So some other things that we talk about with our board members, and we even talk about this even at our training, is that we have to be able to be comfortable asking questions about sex and how it progressed. And in a sexual incident, we have to be able to be comfortable using words that, when we're with our parents, we might not feel comfortable using. So, we have some colleagues, in our department that aren't comfortable talking about things like masturbation or intercourse, and if you're not comfortable using those words, we're frank in our training that this is probably not going to be the process that you want to be involved with. Because if you're not comfortable talking about that, then it's something that's going to come across to those students in an already very sensitive situation, and at best make it awkward for those students, at worst make it re-victimizing for those students. I think one of the things that we also talk about when we're asking those questions, and when we get into the line of questioning where we're talking about very specific sexual acts, is we preface it to those students about why we need to know what we're asking. We need to know very specifically where were hands, or where were your body parts, and how did you ask for sex, because we need to be able to establish by a preponderance of evidence whether or not it was consensual. And then the last bit about credibility that we haven't really talked about is really, it comes down to a little bit more than just believing one party, but really what about the statements makes sense, and are their statements corroborated by other pieces of evidence, whether that's other statements, or is it corroborated by text messages or timestamps, or also just does something just make sense in terms of how you understand the world works and student interactions. And one thing that I really talk about with boards sometimes is that credibility can be one of those things that's hard to define, but you know it when you see it, and when you're listening to a student that yes, they're credible because everything that they're saying makes sense, and that there's a plausible explanation for what they're offering. And there's a lot of times that our cases come down to the credibility of one party over the other, or there's a reason that one party does not seem very credible because there's elements of their statement that are not making sense and don't add up. So that's something that if you don't have that in part of your training, is really important to focus on too, is how are you establishing credibility and being able to explain that also when you're putting that together in a rationale.
And so that's a good lead in for this slide. In terms of our proceedings, a college hearing is not a court proceeding. So the rules of evidence do not apply, which is why we welcome hearsay evidence. And I'm not going to get into the technical nitty-gritty definition of what true hearsay is, but in essence, it's really a statement that's made outside of the hearing. We generally do not allow character evidence because it really doesn't matter whether somebody attends church regularly, and so, people think that this person wouldn't have done such a thing to somebody else. What we need to focus on is the particular incident or incidents that have been reported. In terms of past record, if a student who's accused has been sanctioned in the past for similar type of conduct or other unrelated conduct, that information is only provided to the board after the board has made a finding of responsibility. If the accused student is found not responsible, then that information is not disclosed. In addition, in terms of other information that is not allowed, it's the sexual history of the parties, unless it relates to their own relationship, because that might shed some light on the specific incident that's at issue. In addition, mental health records or that information, that's not allowed, and that's what the law says. So in terms of corroboration of evidence, Dan was talking about that. It might be text messages from one of the parties that help substantiate what one of them has said. It might be information from a witness. It might be a witness who corroborates that after the alleged, after the reporting individual has, that person's behavior has changed dramatically. So that's all corroborating evidence. And when you look at credibility, there are a number of things to consider. Does somebody have a motive for making a certain statement? If you have a situation where there are 5 witnesses and 4 of them are, essentially saying the same thing and one person is not, what might account for that one person who's not saying something similar or along the same lines? So that's all important information to consider. In terms of credibility, though, we hear the expression he said, she said all the time. And I have to say, I can't stand that expression because in a lot of these situations, there's not going to be a witness to the sexual act that's been reported. So does that mean that you can't make a determination? No, of course not, because there may be other evidence. Often, more often than not, there is other information that we may gather throughout the investigation that corroborates one party or the other's statement to us. And, ultimately, if the fact finder decides that they really just can't make a determination one way or another, that in and of itself is a finding of not responsible because preponderance of the evidence is more likely than not. So, next slide, please.
So a lot of our slides could be their own 2-hour, 4-hour webinar. This is one of them. So we just wanted to touch a little bit on interviewing and questioning skills, and more so framing for our audience. If most of our members today are more on the rape crisis side of things, the questioning that we are going to be allowing in the hearing might be more related to this. So, for example, we are not going to be interrogating either party. We don't have the same kind of like law and order feel. So it's not how we are going to run the hearing. What we will ask information from students, and we might say, tell me more about, and whatever it might be. Or I'm not sure I understood this in your statement. Can you elaborate on, the interaction that you had this day prior to the incident, and so on. So it's going to be more in that kind of sense. We do draw a lot from the investigation report, and that's what we encourage our board members to do. So the investigators spent a lot of time investigating and getting information for the board to consider. So we might say, in your statement on page 6, you stated this, this, and this. Can you please explain how that, aligns or contradicts with your statement here? And really draw to the report. So it's important that, our students are aware of that in advance, which we tell them to prepare and have that available, and we will show them it again and ask them those questions. But we're not redoing the investigation. The board is not meant to redo the investigation, to collect all the information. It's to, find the facts and get the information that the board would need to make a decision. So that's something that's really important. We want to focus on the central issues at hand and not kind of go on these random tangents about irrelevant things. And, the questioning that questions that you might help your reporting individual pose, might follow along these lines. And Christi kind of laughed earlier when she talked about helping prepare questions, because there's times when I've had to block her questions, and we talk about it. And there's most often, we'll take a break too. If there's a discussion that needs to be had about the questions, the board chair will typically take a break, and then the students will be dismissed to go into their waiting rooms, and the board chair will go and speak with them and say, okay, you've submitted these questions. I'm perceiving these to be pretty redundant, or this is, what are you trying to get at here? This does not make any sense. It does not seem relevant at all to me. And then they'll explain, and we can try and figure out, what question could be asked, if anything, and moving forward. So there's definitely a dialogue around questioning with the advisors and with the students involved. But our board is, again, going to ask questions similar that are on the slide. I'm not certain about what you meant by this. Can you tell me more about that? And probe a little bit further.
All right, in terms of, what did I do?
Bear with us one moment. We wouldn't be a webinar without some technical difficulties. So we'll hopefully just check that box that we just had one now.
Sorry about that. Thanks, Dan. So in terms of using trauma-informed practices, it's so important for us to do that because we know that somebody who's been a victim of trauma may not remember things in a way that somebody else who hasn't been a victim of trauma would. So, in terms of the neurobiology of the brain, the primitive part of the brain functioning and their ability to remember things like the five senses, but not the logical part of the brain not being engaged during the trauma. So it's important when we ask questions of the reporting individual that we not sound accusatory or judgmental by asking why questions. And I think Sara gave some examples in the last slide of how to ask questions and get the information the same way, the information that we need to get. And it's important for us to consider, if part of the complainant's report doesn't make sense, why might that be? Is that because of the effect of trauma on their memory? Is that because they have lost pieces of the of the experience because they were focused on just surviving the incident? So once we have an understanding of what was going on and how they were impacted, then we can determine whether or not information makes sense or not. But, we have to be really careful in assessing credibility of the reporting individual, that we don't hold against them the fact that they don't remember things in a chronological order, or that they've given some inconsistent information after they made their first report, and the first report may have been made, shortly after the incident happened. So this is really in keeping with balancing the scales of justice rather than tipping it in favor of the reporting individual. And that's really a part of ensuring that we are being equitable to both parties because, as I said, somebody who's been a victim of trauma may have problems with their memory in terms of remembering some of the details or might have gaps in their memory. Whereas the accused person, if in fact they committed, whatever has been alleged, wouldn't have that problem. They weren't under traumatic conditions at the time of the situation. So we don't want to tip the scale in favor of the accused by not taking trauma-informed practices into consideration. And I don't know if any of you are familiar with FETI. I'm guessing that some of you may be, but it's something that we've been learning a lot more about here at the College of Brockport, and it stands for the Forensic Experiential Trauma Interview. Russell Strand is the person behind that, and he's done a lot of research, and his practice has been an investigator or detective for, I don't know, I think he said like 30-plus years. So what he has found is that when we ask questions in a chronological order of a reporting individual, we are going to be missing some information. It's going to be told in kind of a black and white situation rather than adding the color to it. And what he talks about is that really when we ask other questions that we might not think about, except if we're in this line of work, then we get a fuller picture. It really becomes more of a 3D kind of experience that we can understand much better as investigators or as board members. So the questions that he talks about using in standard practice would apply both during an investigation and at a hearing when you're trying to gather more information that might be missing from the report. And those are, what are you able to tell me about, whatever the experience was? What was your thought process during this experience? What are you able to remember about? And then, asking about smell or what they were feeling at the time, physically. There was a situation that we heard about during our training. I'm going to ask Dan to share because he has a better memory of what that situation was.
Yeah, so this was an example that really stuck with me from an investigator at a university that came and presented with us, where she was talking about working with a woman who had reported to her that she had been sexually assaulted in, I believe it was a fraternity house, and she remembered the house, but she didn't remember many other details about what had gone on. And while the investigator was meeting with her, this student really started kind of hedging her bet, kept saying, I don't remember anything, and was getting a little frustrated. So the investigator started, pulling out, talking about smells and, anything else that you remembered. And the student started getting kind of dismissive about, something that she was recalling. And she said, you know what, this is crazy, like this can't make any sense to me. But what I remember is while I was being assaulted, feeling fur around me. And, so the investigator made note of that and said, we can follow up on that. And in some proceedings, they followed up and they went to this house with the police. And sure enough, on this, when they walked into the room where this had supposedly occurred, they had found a bearskin rug. And so that was one of those cases where, this woman remembered just this physical sense but couldn't remember any other details, and it was corroborated by other evidence that, was found when they went into this house. So that really also strengthened the credibility of her statement that, that otherwise, without understanding the FETI method, we'd be looking for a completely linear sense of a statement with other facts that she just wasn't able to present because of the trauma.
Thank you, Dan. And it's my understanding somebody asked what FETI stands for again. It stands for the Forensic Experiential Trauma Interview. If you type in FETI online, that'll pop up. So FETI is a search term in and of itself, and I think we'll provide a lot of information about this to you that we're covering. So some other important questions. What was the most difficult part of the experience for you? This came up for me in a recent interview with a reporting individual, and what she described was something very powerful in response to that question. She was subjected to forceful intercourse, and at the time she didn't recognize it as necessarily having been non-consensual sexual intercourse, but it took her a while to process that. But she said what she cannot forget is the physical pain that she felt from that situation. This is with a partner of hers. They were in a romantic relationship. So, what I got from asking that question was a much fuller description of really how this impacted her. And then the other question that can bring up a lot of really helpful information that Russell Strand, again, kind of the founder of this practice, talked about is what, if anything, are you unable to forget about your experience? And he talked about a situation where somebody he was interviewing was asked a question, and the man started hitting his head. And before that, he couldn't really remember details. But after he started hitting his head and talking about how all he remembered was something, or what he could not forget was, I think it was something hitting him in the head, and I don't remember what the details were now, but that brought back all these other memories about the experience for him. So sometimes when you ask these questions, it'll open up the floodgate of memories that may have been that the reporting individual couldn't access before.
So the board themselves will be looking at, three main areas, but it's important to note that whatever the charges are that are placed on the accused student, that's what they're reviewing more heavily. The definitions in our code, how are those charges defined, and with that, they're going to be looking at a few of these pieces. Was there evidence of force? Is there evidence that the complainant was incapacitated? And, was there an issue of consent? And it is important, like I said, to be very familiar with those specific definitions or pieces within the Code of Conduct and whatever document the college is using for that, because that is what is going to be guiding the board's decision-making process and will be very, very important because they're not all defined the same everywhere. And, for example, we have in our Code of Conduct that it's not an excuse, and don't quote me, I mean it's general, but it's not an excuse that both parties are intoxicated, and that, so these are things that you want to become very familiar with in reading every specific piece of the code and how it relates to affirmative consent, for example, or incapacitation.
All right, so real quick, because I think we've covered a lot of this, again, looking at the motivation of the parties when you sift through all the information to make that determination, looking at all the evidence, as Dan referenced in our investigative reports, we have a section that discusses the material facts, what are the undisputed material facts, and what are the disputed material facts, and we go through for each witness what is in dispute. So focusing on that can really help you figure out what's at issue and then ultimately what your decision is about responsibility or not. In terms of direct or circumstantial evidence, it's not that one is stronger than the other. They're both equally valid. And an example that I give related to circumstantial evidence, what is that? That can be something that people think is about kind of vaguely, not really understand exactly what it is. The example I give is, did it rain? So take the subway to work. In Brockport, it's a big city with the subway. If I take the subway to work and I'm on the train and I see people getting on at different stops and they're bringing in their umbrellas and the umbrellas are wet and their clothes are wet or their coats are wet, their hair is wet, I'm going to have a pretty strong sense that it's raining outside. I get off the subway at my own stop. There's no rain now. I can still deduce that it rained at some point, at some period of time while I was on the subway. Whereas direct evidence would be, while I'm waiting for the train to come, I see the rain. Or as I'm on the subway and it stops, I can see the rain outside the windows. So that's the difference between direct and circumstantial. And that's all I've got for that.
Great. So the board has a lot of work, as you can see. They have a very big task at hand, and then after the hearing, they spend a lot of time deliberating. So our practice, which we think is the best practice, is that the board will deliberate briefly right after the hearing, but then we'll schedule another time so the board to really spend some time, a couple of days or a day after the hearing, and we ask them to re-review the investigation report, review all of their notes from the hearing, and we can certainly access audio recording and so on, but really it's important for them to not only have the information presented right in front of them at the hearing, but all the information collected throughout the process so they can make their decision. So that's something that we found to be successful too, so that they're looking at the full picture. Also, it's a majority vote, so we always have 3 or 5 people on purpose so that there's not that issue with the voting. And they really will look at each specific charge and go through that with the facts and information that they have presented and determine if the accused student is responsible or not for violating those specific charges based on our specific policies. And I know we're kind of harping on that, but it is very important that we continue to direct the board to the policies that we have here at Brockport, or whatever institution that you're going to be working with, because they could all be slightly different, and that's what the board is responsible for determining, is that the specific policy and charges that were issued before. Also, the personal feelings should not influence the decision, of course. I mean, it goes without saying, but that's something that we really train our board members on. And, they need to construct the most reasonable scenario during their deliberation.
It can be hard, though, because if you don't like one of the parties, you're really, it's an emotional thing. And so I just want to put out there that it's not an easy thing. It can be very difficult to put aside your personal feelings.
And that's the board chair's job to kind of keep that in check, too, and start to, understand and sense when that might be happening and probe into that further and determine if, there's something that needs to happen there. But typically the board chair will ask questions like, okay, so tell me the facts you're using to base your decision on for this specific policy. And then the board chair is responsible for drafting the letters on behalf of the board. So the outcome letter that the students receive, which both students would receive, and they receive it at the same time via email, as well as a memorandum of opinion, which articulates the reasoning why the board made that decision. And again, both students receive that as well.
Do you want to talk about the two different meetings, or did you want to make that? Two different meetings? We're waiting.
I did.
After that. Okay, sorry.
So this is our last slide, and that we really want to end with is to remember that in all of our proceedings is that the standard of evidence required by law is preponderance of evidence. And that's a different standard than we would use in our courts of beyond a reasonable doubt. And this is another thing that we really spend some time on with our boards in the training to help them understand that we're not always going to have smoking gun evidence. It really comes down a lot to statements and credibility of statements and whether or not those statements are corroborated by other evidence. But when we're saying a student is responsible, we have to get beyond 50%, so 50 and a feather or more likely than not. And another thing that I really caution with the boards is to be cautious against slipping into a higher standard, and start looking for 60% or 70%, knowing that a finding of responsibility means that you have to suspend a student. And I think we've done well with that here at Brockport, but I know that can be a tendency and something that board members that don't work with conduct can sometimes feel uncomfortable with feeling like they're just over 50%, and that means that a student will be suspended or dismissed. But by law, that's what we have to do. That if we're saying this is the most likely version of events, and that version of events would be a conduct violation, then we would suspend. So just a really important thing to understand, and that I think also that sometimes our outside constituents really have trouble understanding in terms of how we're different than, one of the big areas that we're different from a court process.
I just want to chime in, though. So beyond a reasonable doubt is a standard for criminal court. But in most civil cases, it is preponderance of the evidence. And with civil rights cases, it is preponderance of the evidence. So I just want to be clear about that.
Yeah, that's a good point. So I think that is our last slide, and then I know Michelle had some slides after this. So we'll hand it back over to you.
Thank you so much. Wow. My head is spinning. I want to thank everyone that sent questions in over our chat function. I have them here. I want to thank our presenters for their absolute wealth of knowledge and willingness to share their resources, experiences, and best practices. As I said at the beginning of the webinar, this is being recorded. I will share the YouTube video with everyone who is registered, and this will also be available, of course, on YouTube as well as on NYSCASA's website. So before we get into the question and answer session, I have one last poll to do, and that will hopefully give everyone enough time to send in any extra questions that they have, as well as to review the poll. So the poll is, I'd like to know how you felt about the webinar, whether it was too advanced for your use, too elementary, or helpful and enhanced your skills. I'll give everyone a few moments to complete that. Send in any extra questions that you have before we move to the question and answer session.
I just want to say if we don't get good results, we're not answering any questions.
Fair enough. Fair enough. I'll just give it a few more moments. All right, great. Let's move into the question and answer session. So please continue to send in your questions, and I will start. So one question that came through our chat box was, how does the process differ when a reporting individual and respondent are not students? For example, if one party is a professor.
In that event, then we have an affirmative action officer who will also investigate. If it's a faculty member and a student, we will work together. But here at the College of Brockport, most of the faculty and most of the employees are members of unions, so we have to abide by the collective bargaining agreement and take that into consideration during that process. It is a separate process than the process that we have just talked about today.
Okay. And how does the process change or not change if if the reporting individual and the respondent are both students, but one of those students is also a TA or has some sort of leadership position on campus, like a manager at student employment?
Well, I'd say, in that type of example, their primary relationship to the university is student. So that means that they would be held accountable to the Code of Student Conduct, and they would go through the process that we would have. If they're, in their employment role, we don't always share out, that a student is going through this process, but if they're in their leadership capacities, if they were to learn of the process, there would be an employment decision by those offices. If I'm trying to think of some examples. Let's say we had, a union manager or an RA or like those undergraduate student leadership type roles. Those are the types of things where, depending on the nature of the circumstances, we would probably have to consider some, maybe some interim measures or some interim employment action, and that would be, something that we would be considering. And I think that's also really underscores the importance of our Title IX case management team, that because we have different partners on that team with, representing different areas of the college, we're exploring not only what is the impact of, this incident between the two students, but what is the impact on the community in a broader sense, and where do we need to do some interim remedies if we're going to proceed with an investigation.
And I think that also, if the question is, if the reporting individual is both a student and an employee, I think we have to look at in what context the report occurred. If it occurred because of the person's role as an employee, then how we proceed might depend on that, in terms of whether it's through the affirmative action officer or our process. And I can think of a situation, for instance, where an accused might be a graduate student, and in that situation maybe, could be subjected to, for instance, sexual harassment by the chair of the department, or could subject a student in the class that they're teaching to sexual harassment. And you just have to look at what that role is and what's going on before we'd make that determination of how to proceed.
Okay, great. So the next question I have is the clarifying question. How many Title IX investigators are at SUNY Brockport?
We have 10 trained investigators.
Okay.
And as Sara has talked about, the investigators have gone through a TICSA training or the National Center for Public Safety training, or the one-day SUNY training, or could be all of them, and in addition to a number of other trainings. So we really do focus a lot on training because it's so important to the whole process.
Absolutely.
And let me just also say that, for instance, Sara, Dan, and I all all are investigators, but we have other people who are investigators who are not a part of student conduct or Title IX, and they have other full-time positions here. So this is work that they do in addition to their full-time work.
Absolutely. Let's see, I have another question here. One of our participants asked if there was a time limit that Restore could work with students, whether or not it went beyond short-term or long-term therapy.
Nope. We will work with students, as long as they're appropriate for our services. So that could be, before, during, and after the conduct hearing itself. There might not even be a conduct hearing. And we have office space on 6 of our campuses, and we just see folks for short-term counseling, but there's no number associated with that. We're not going to cut someone off at, say, 6 visits and say, sorry, that's short-term, move on. So we'll work with them as long as they're continuing to, debrief and cope with their whatever their situation may be. If we suspect that there might be some more, deeper long-term trauma or something going on mental health-wise, we're going to refer back to the counseling centers on campus or to an outside, licensed counselor or therapist.
Thank you. Is the process altered if either the respondent or reporting individual is classified as having an intellectual or learning disability?
Yes, I think we would take that on a case-by-case basis. In terms of equity for the process and having access to the process, we would work with that and try to figure out, what is the best way to accommodate whatever that need is. And whether that means, and that might mean working with our disability services office to figure out how to accommodate that. For example, at my previous institution, there was a lot of deaf and hard of hearing students there, so we would regularly be coordinating with interpreters. But if they didn't use American Sign Language, we may have a case where we had to have a captionist typing out literally everything that was going on with the case, so that person would have access and met their needs appropriately. So that's it's a really case-by-case basis, but the really straight answer is just yes, because we would have to provide access to the process in whatever way accommodated their disability or their need.
But substantively, the process would be the same. Procedurally, right, we would accommodate, but in essence, it would still be the same process. We just would be accommodating.
Yeah.
So
yeah. I guess I was thinking more logistically.
Yeah.
Excellent. Great. Thank you. Let's see. The next question I have, what does the training look like for investigators, and is it the same training that your hearing board goes through?
No. So the training for investigators, we've mentioned it a number of times about ATICSA and SUNY and National Center for Public Safety. So typically they are days long, extensive hours long, and sometimes quite expensive depending on the organization. But it ranges a variety of topics. I encourage you to research that, and it's really quite an industry now actually to pursue. But the board members receive training that's similar in content and concepts, but is different because they're not doing an investigation. They're serving on the hearing board, which again we've included some topics from the hearing board trainings that we've provided in the past, and some issues of that throughout the session today.
Okay, great. All right, that is actually all the questions that I received during the webinar, as well as during this question and answer session. So I want to turn it back to our presenters to see if you have any final words before we conclude today's webinar.
No, just thank you all for listening, and we're happy if you'd like to email us and send any questions. We'd be happy to remain in contact. So thank you all.
Excellent. Thank you all so much for your time. Again, your expertise I know this has been extremely informative for me on my end, and I really look forward to sharing this recording with our participants as well as with the larger lists of the New York State Campus Consent Consortium, as well as on our website. I think this will be really, really helpful for everyone. So thank you again, and that concludes today's webinar. Stay tuned tomorrow for the recording, the PowerPoint, as well as information about the Campus Consortium's working group. Thanks again.
Thank you.
Thank you.